with your host, Jaden Miller.
Good day and welcome to Think About It with Jaden Miller. I'm your host, Jaden Miller. Hope you all are doing well. Hey, as I always state at the beginning of my podcast, and I probably do during the middle and the end too, please like, share, and subscribe on my YouTube channel, and like, comment, and follow on your favorite podcast platform. As I state again, every episode I am on Spotify, Apple Podcasts, Spreaker, Google Podcast, Castbox, SoundCloud, iHeartRadio, and all of your favorite podcast platforms. I, again, thank you for joining me today on this next episode. So, as I began this podcast journey, I kind of started off as, wanting it to encompass a multitude of different topics or areas for discussion. And I think maybe that worked to some degree, but, I've heard from experts and others that state that you should find a niche, and I think I found mine. So I had a first season that had about 32 episodes, and now I have begun my second season. And so as I've thought about this whole niche thing, as many of you that may be listening know, I have taught for years, many years, at the college level and at the high school level. I am in grade school administration now, former member of law enforcement, retired. And so I figured that what I would do is I would use my knowledge and experience in more of an educational area to share facts and then, of course, share my opinions as it relates to certain areas in education, mainly areas that I taught. So at the college level, I taught criminal justice courses, and in high school, I taught American government and economics classes. And so I think what I'm going to do is I'm going to really focus in that area, and it may at some point delve into politics or something else like that from an historical perspective, and maybe from a present one, just to make an argument or make things more clear. And so I decided to just kind of focus on that which I know. And so that's the direction that I've decided to go, but it will still be interesting, and everything I say is still relevant to what's going on today. And so my topic today is going to be, again, a topic dealing with that which is taught in classes that I've taught many, many times, and that is the Miranda versus Arizona United States Supreme Court decision. I'm going to talk about how it came to be and why it's still so important today. So this was a decision, the Miranda versus Arizona decision, that was ruled in 1966. And basically what it does is it restricts prosecutors from using a person's statements made in response to interrogation in police custody as evidence at their trial, unless they can show that the person was informed of the right to consult with an attorney before and during questioning, and of the right against self-incrimination before police questioning, and that the defendant not only understood these rights but voluntarily waive them. All right. And so with the Miranda decision, you'll see that it is a combination of the Fifth Amendment and the Sixth Amendment to the United States Constitution, made applicable to the states through the 14th Amendment. And it's important that you all remember that the Bill of Rights, those rights contained within the First Amendments to the Constitution, those rights apply to the federal government. Okay, they applied to the federal government. It wasn't until the 14th Amendment where the Bill of Rights, the amendments to the Constitution, were made applicable to the states. And I'll talk about that a little bit in just a moment. But let's go back and talk a little bit about why Miranda came to be. But before I do that, let me just go back and just let you know that there's a reason why we have these Bill of Rights, okay? And it's very, very simple. It deals with the fact that this country, under the auspices of Great Britain, remember this was a colony of Great Britain, they were being treated unfairly by King George III and by Parliament. All right. And therefore, after a great deal of upheaval, they decided, meaning the founding fathers decided, that it was time to separate. All right. Meaning that we want our own country, simply because there were so many atrocities committed against them. All right. And therefore, our founding fathers decided to fight a war of independence. And Thomas Jefferson, of course, the writer of the Declaration of Independence, wanted to ensure that these people in this now new nation, the United States of America, that they had the right to life, liberty, and the pursuit of happiness. All right. And then those things had to be contained within a Bill of Rights to ensure that people were not being mistreated like they were under the rule of King George III and the British Parliament. Okay. All right. So that's why we have a Fifth Amendment. That's why we have a Sixth Amendment. All right. And it is so important that we have those things because it guarantees us, all right, certain constitutional rights. It guarantees, all right, that we shall not be compelled in any criminal case to be a witness against ourselves, nor to be deprived of life, liberty, or property without due process of law. That's so important. All right. That whole concept of life, liberty, or property comes from English philosopher John Locke, okay, who was heavily influenced our founding fathers with this philosophy on how government should respond to the people, but more importantly, how people shall create a government, okay, that works for their benefit. All right. So that's really, really important just as a background to provide. All right. OK. We shall not or should not be compelled to testify against ourselves without due process of law. All right. What does those things mean? Well, let's take a look at Miranda, for example. Ernesto Miranda was by all means not a nice person. All right. He was born in Mesa, Arizona on March 9th, 1941. He was the type of kid that encountered law enforcement while he was still in grade school. OK. He was a product of a broken home. His mother died when he was young. His father remarried. It was not a happy home for him. When Ernesto Miranda was in 8th grade, he was convicted of his first crime. The following year, he was convicted of burglary and sentenced to a year in reform school. Okay. About a month after his release from reform school, and this was in about 1956, he was arrested and returned to reform school at the Arizona State Industrial School for Boys. After his second release, he moved to California. Shortly thereafter, moving to California, he was arrested for armed robbery and was accused of some sex offenses. Well, After living in California, Miranda became a drifter, moving throughout the Southwest and the Southeastern states. He was arrested in Texas for living on the street, arrested again in Nashville for driving a stolen car. And because he was driving this stolen car and crossed state lines, okay, he spent a year and a day in federal prison, okay? So it's really ironic, and it just so happened that his case, the Miranda versus Arizona case, was destined to make history and become a major part of our legal system. So, on March 13th, 1963, the police were looking for a suspect in connection with the kidnapping and rape of an 18-year-old young lady. She told police she was accosted by a Mexican man who wore glasses as she was leaving her job at a movie theater. Ernesto Miranda was accused of forcing her into his car, taking her into the desert, and criminally sexually assaulting her. All right. A week later, the girl and her brother-in-law spotted what they thought was Miranda's car and called police. Well, this happened in Phoenix, Arizona. So Phoenix, Arizona police officers stopped and confronted Miranda. He voluntarily went to the police station with the police and participated in a lineup. Now, the victim was unable to identify Ernesto Miranda in the lineup, but the police told Miranda he had been positively identified by the victim. After 2 hours of interrogation, Miranda confessed to the crime. Now, later on, his confession, as it relates to his confession, he went back and said, well, no, it didn't happen that way. Okay? He said that when he recanted his confession, it was very brief and the facts differed in many respects from the victim's description of the crime. All right? So the form used to get his written confession contained a header stating, "This statement has been made voluntarily and of my own free will with no threats, coercion, or promises of immunity and with full knowledge of my legal rights. Understanding any statement I make can and will be used against me." Okay, that's what it said. So during the entire interrogation, no one informed Miranda that he had a right to consult an attorney or that he had a right to remain silent. All right. So during his trial, the court assigned a 73-year-old lawyer, all right, to represent Miranda. All right. His attorney objected to the admission of the confession, but this was overruled by the judge in that case. All right, we're talking about a local case. All right. So Ernesto Miranda was convicted and sentenced to 20 to 30 years in prison. All right. His conviction was appealed to the Arizona Supreme Court, but the Arizona Supreme Court also upheld the conviction. All right. So now you have to think back to the times that we're living in. Back in 1963. All right. A couple of years before the court actually hears the case. All right. What's going on in the country? Well, during the turbulent 60s, we have a civil rights movement that is going on. All right. And therefore, you have lots of different organizations that are looking at how the police. Okay. You're looking at how criminal courts, are they really unbiased? All right. Ernesto Miranda is Mexican. The question is, if he were not a person of color, would the police have used the tactics that they used in order to get a confession out of him? All right. And then we also have to look at least when we talk about the United States Supreme Court, we have to look at the makeup of the court. All right. Well, during this time, the Chief Justice of the United States Supreme Court is Earl Warren, okay? And Earl Warren is a more liberal justice, all right? And so during his tenure, his leadership on the court and his vote on the court tend to sway in a direction that is more amenable to criminal defendants in some degrees, not all right? Earl Warren wrote the majority decision, or actually the unanimous decision for the most part, in the Brown versus Board of Education decision, all right? And he was involved in quite a number of other decisions that swung how police and how swung the country more in a liberal direction as opposed to the way that it had been, based upon an originalist, view of the Constitution, and, there's no room for social justice and those kinds of things. All right. So you had the American Civil Liberties Union that got involved in the case. All right. And then you had others that joined on to this case as it was moving towards the United States Supreme Court. And so in November 1965, the United States Supreme Court agreed to hear the Miranda case along with 3 other similar cases. So when we talk about Miranda is the prime case, but there were 3 other cases going on at the time. There was Vignera versus New York. Okay. There was Westover versus United States. And these are things that you guys can look up. And then there was California versus Stewart. All of these issues dealt with statements obtained from individuals who were subjected to custodial police interrogation. All right. So that's what those cases dealt with. So the court was looking at all of those and decided that Miranda was going to be that main case. That was going to be the landmark case for the United States Supreme Court. All right. So now we have Miranda, who has been convicted. His case was overturned by the Arizona Supreme Court, and now it makes its way to the United States Supreme Court. All right. Well, what's in question here is the Fifth Amendment to the Constitution and the Sixth Amendment. All right. What do these guarantee? The police have a plethora of resources. They have the law. They understand the law. And then you have some criminal defendants who are uneducated, don't understand the language, especially if they're from another country. Excuse me. And so they have a disadvantage when it comes to understanding the law. Not only that, all right, a lot of Americans, not let alone citizens from other countries, but a lot of Americans do not even understand their own basic rights. All right. And this is important for you to remember. All right. As a teacher, I've asked many times when I was teaching during American government classes, anyone, just tell me what 5 or 6 of the Bill of Rights say. OK, and then explain them. All right. And it is very difficult to get a lot of American citizens to even know what's guaranteed them in the United States Bill of Rights, the first 10 amendments to the Constitution. And that's startling. All right. That a lot of people don't understand. All right. A lot of people don't understand that, prior to this country's founding, that British authorities, we can call them law enforcement, whatever, that they would get confessions out of people by torturous means, that they would trick people into confessing, or they would say someone confessed. even though they did not. All right. They would drag people clear across the ocean back over to Great Britain to stand trial. All right. They were doing all of these things that certainly violate a person's not only civil rights, but their human rights. All right. And so that's why it's so important that when the courts take a look at the Constitution and the constitutionality of, police actions or anybody's actions or government actions, rather, that we remember what was the main goal of the establishment of these rights. All right. It was to guarantee us these freedoms. All right. So now, it really amazes me how some people are against the Miranda decision. There's an argument, as to, has this decision altered the way that police are able to police? And as someone that has worked in law enforcement, it has not. It simply guarantees a person's already given rights. Okay. Again, based off of the tyranny perpetrated upon this country by Great Britain. All right. So it's extremely important that we remember that and that we keep this in mind when we as a government, we as a people decide that we want to limit government actions. I think sometimes people forget that the government works for the people. Okay, we, the people, establish government. We establish government because we want protection. There are certain things we want from the government. We want protection. We want decent roads to drive down. Okay, we want our airways to be free. Okay, we want, schools that are going to educate our children. Okay, so we establish government to make sure that we have these things. This is for the good of all of us. This is for the good of society. All right, but when government works against us, okay, then that government is not being effective. It's not being effective. All right, so the idea behind Miranda was to protect the weak, the uneducated, and the innocent from coerced confessions. All right. So the thing is, when we look at Great Britain and its rule over the 13 original colonies, you had British government, British government agents that were ugly acting. They were mean-spirited. I'll put it in today's terms. All right. Well, human beings have been human beings since the beginning of time. All right. And sometimes when you give people the authority of the state, including those that are in high government offices or law enforcement or what have you, that they will not act in the interest of the benefit of the people or the government, but they'll act in their own selfish interest. All right. And so that's why we need to regulate government activities, because we don't want a government that's tyrannical like the one that our founding fathers fought a war to get away from. Again, very important for you all to remember. All right. So in essence, this is what happened. There was a 5-4 decision, all right, based on the Fifth Amendment protection against self-incrimination, all right. And what the court talked about was the English Star Chamber in the 1600s, when the privilege against self-incrimination first became an issue in the courts, all right. The Supreme Court used the warning already in use by the FBI as its model for the Miranda warnings. All right. So the FBI already had a somewhat kind of model for what Miranda warnings should be. All right. I'm jumping ahead a little bit, but just so you know, when police tell you that you have the right to remain silent, this was not something that was ordered or developed by the Supreme Court. This is something that was developed by law enforcement to make sure that they provided you with the rights that the Supreme Court decided you need to be told. Now, when it comes to Miranda and the Miranda's decision, these rights against self-incrimination, to have the right to an attorney present with you during question. So we're talking about the Fifth Amendment and the Sixth Amendment, that they apply to anyone that is in the United States. All right. So now we have to go back to the 14th Amendment to understand why that's important. But before I do, let me go back and just give you a quick refresher of the Fifth Amendment. It simply says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. That's the double jeopardy portion of the Fifth Amendment. All right. Now, this is the part that's really important to us. It is, nor shall be compelled. All right. No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. What is due process of law? That means that in a criminal case, having a trial, all right, having the opportunity, all right, to have witnesses to come forward on your behalf, meaning that you are not responsible, okay, for testifying against yourself or bringing a case against yourself, that the state must have overwhelming evidence, all right, against you. All right, that you have the right to an attorney, as I've already mentioned, that, you know, if you don't have an attorney, then one can be provided for you. OK, that's all a part of due process. OK, meaning that they can't take you from, if the crime committed in California and it's a state crime, they can't try you in Mississippi. OK, all right. That's what we talk about when we talk about due process. All right. Then we need to take a look really quickly at the Sixth Amendment. All right. And in the Sixth Amendment, it says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. We're talking about due process. To be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. All right. So that's the Sixth Amendment. All right. Very important. But you have to remember that the Fifth and Sixth Amendment apply to what government? It applies to the federal government. States have rights. The 10th Amendment says so. States have rights. All right. So that's why you have in states, they have a constitution. Well, don't we have a federal constitution? We do. At the federal level. All right. So we have a state constitution. All right. Can cities, enact laws? Absolutely, they can. Okay. And as a result of that, again, when we talk about these amendments, they pertain to the federal government. Now, there was a little war that was fought in the 1800s, the Civil War. Okay. The Civil War was fought for a number of different reasons, which I don't want to get into today. But after the Civil War, you had about 4 million black people in this country with no political distinction. All right. And so there had to become a political distinction. That's one. All right. Then there's this second part to it. All right. That remember that the Bill of Rights applied to the federal government. All right. So now after the Civil War, the federal government has to ensure, okay, that its laws apply not only at the federal level, but to states as well. So we have the 14th Amendment that really took care of a lot of things that were lacking. What does it say? All right. It says all persons born or naturalized in the United States. Now let's go back because it's important to remember. Why does it say all persons in the 14th Amendment? All right. When it says that in the Fifth Amendment, it says that because remember, after the Civil or prior to the Civil War, African Americans were not considered persons. Okay. Nor were they considered citizens. All right. Now I'll get to that in just a minute. But it establishes now, the 14th Amendment, that 4 million black people in this country are persons. All right. That's the first part. You have to establish who they are. All right. Because in the Constitution prior, for legislative purposes, black people were considered 3/5 of a human being. 3/5, not a whole person. So now it establishes that all persons born, meaning if you were born in the United States, whether you were a slave or whatever, well, you're not a slave now because the 13th Amendment freed you, but you just didn't have a political distinction. All right. So now you are a person. All right. So it establishes that. And it establishes that if you were born here or naturalized in the United States, meaning that you maybe were brought here. All right. All right. And it goes on to say, the 14th Amendment, and subject to the jurisdiction thereof. What jurisdiction? The United States. The United States. All right. Now it goes on to say that all persons that are born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So now they've established that blacks after the Civil War are now citizens of the United States. And this is the key word, and of the state wherein they reside. So not only do you have citizenship at the federal level, you have citizenship at the state level as well. All right. Now it goes on to say, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. All right. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So it simply means that now at the federal level, if there is a law at the federal level, okay, and that gives you privileges or immunities as citizens of the United States, that no state can abridge those, meaning they can't restrict those, make them smaller. No. All right. It goes on to say, nor shall any state deprive any person of life, liberty, or property without due process of law. Where have you heard that before? You've heard that in the Fifth Amendment. All right. So why does it need to be repeated again? In the 14th Amendment, it says no person shall be compelled in the Fifth Amendment. No person shall be compelled in any criminal case against him. No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. That's in the Fifth Amendment. Okay. It goes on again. It says, nor shall any state deprive any person. All right. Well, remember in the Fifth Amendment, it also says himself. Aren't women citizens? Okay. Well, if you weren't, now you are, according to the 14th Amendment. Nor shall any state deprive any person of life, liberty, or property without due process of law. That, again, makes the 14th Amendment, that makes the Bill of Rights, that makes the laws of the federal government applicable to these states as well. And then finally, this is important too, it says, nor deny to any person within its jurisdiction the equal protection of the laws. That means what's right for Ernesto Miranda is right for Earl Warren. Okay. It has to be equal protection. All right. No state shall deprive any of these things. All right. So that's why that's important. The Bill of Rights, those federal laws at the time, were made applicable to the states via the 14th Amendment. It says no state shall. All right. So now let's go back to Miranda. All right. During the 1960s, a movement which provided defendants with legal aid emerged from the collective efforts of various bar associations. All right. This applied to the Escobedo case. Escobedo versus Illinois is the United States Supreme Court decision that said that criminal defendants must be presented with counsel and that they can have an attorney with them during police interrogation. All right. So again, we're talking about this era in time where the Warren Court wants to establish and ensure that people understand that when they are in the custody of the police, they have a right to do something. All right. And that something is to remain silent. Remember, the Fifth Amendment says that you cannot be compelled, okay, to testify against yourself, to be a witness against yourself. All right. Well, this was not happening. All right. So if you're ignorant and uneducated and the police are interrogating you for hours at a time, okay, and using language or using words that may trick you up because you're uneducated, is that fair? That is not fair. All right. So on June 13th, 1966, the Supreme Court issued a 5-4 decision in Miranda's favor that overturned his conviction and remanded his case back to Arizona for retrial. All right. The court ruled that because of the coercive nature of the custodial interrogation by police, okay, no confession could be admissible under the Fifth Amendment self-incrimination clause and the Sixth Amendment right to an attorney unless a suspect has been made aware of his rights and the suspect has then waived them. All right. This is what the court said. The person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during interrogation. And that if he is indigent, meaning he cannot afford an attorney, that a lawyer will be appointed to represent him. All right. So the court also made clear what must happen if a suspect chooses to exercise his or her rights. If the individual indicates in any manner at any time prior to or during question that he wishes to remain silent, the interrogation must end. It must stop. If the individual states that he wants an attorney, the interrogation must stop until an attorney is present. At that time, the individual must have an opportunity to confer with the attorney and to have him present during any questioning. All right. So it's very important that we understand that the Miranda rights are there to protect us as United States citizens. Some people try to bring politics into this. This is not about politics. It's about protecting you and making sure that you are aware of your Fifth and Sixth Amendment rights guaranteed by the Bill of Rights made applicable to the states by the 14th Amendment. It's extremely important that you know that. So that's why I tell in my classes, my students this. Law enforcement, which I was a member of for quite a long time, is a wonderful resource in government. Okay. They have the job of protecting. They have the job of ensuring that the public is safe and secure. Many of them put their lives on the line, and many of them have lost their lives. All right. And so law enforcement in this country should be respected and and looked up to. All right. But we also have to remember that law enforcement does not exist on an island of its own, and that they get their powers from the people. Okay? From the people. All right? They are giving you the right to do the things that the people don't want to have to do. Okay? Or don't have the training to do. All right? And so that's important. All right? And so it's really important that we remember that, and that we honor our law enforcement officials, okay? But then also we have to protect our rights. And sometimes our law enforcement officials, okay, go astray. Just like we have doctors that go astray. We have judges that go astray. We have attorneys that go astray. We have used car salesmen that go astray. Okay. We have people that live right next door to us that have been convicted of crimes go astray. All right. Because it's all human. All right. And so we have to make sure that we have laws. We have things written in place to curtail people back to where they should be, so that we don't have loss of life or loss of liberty or loss of property. Okay. All right. So that's important. All right. So this decision was very, very important. So let's kind of break it down and see what it means. It means simply this. When the police confront you, okay, and they take you into custody, okay, meaning you do not have the right to leave, okay? For example, they put you in handcuffs, all right? Or they put you in a squad car and take you down to the police station. Or when you say, nope, I don't want to go with you, I want to go somewhere else, and they tell you, sorry, but you can't, all right? Then you are in custody. All right. This is very different than if you're on the street and the police walk up to you. You're free to walk away and they want to ask you questions. All right. You're not in custody. All right. But you're in custody when your freedom has been restricted. All right. So now there's two parts to this. When we talk about the Miranda decision, you have to be in custody. All right. And they are interrogating you. All right. An interrogation is different than an interview. An interview is to ascertain certain information, not to be used against you, okay, but to develop more information about what is in front of them, what is going on at the time, okay? You may ask witnesses questions, okay? You may ask victims questions. Those are interview questions, okay? An interrogation is one in which you clearly are being targeted. And the questions that are asked in a way that may get a confession out of you. All right. Get information out of you that can be used against you in a court of law. OK, if you are a witness, well, there's no information to be used against you. OK, you might be providing what you saw. OK, but it is not about something you possibly did. There's the distinction. All right. So in custody, interrogation. Those two things go hand in hand when we talk about the Miranda decision. All right. And what the police must do. OK, if they are going to interrogate you, is they have to say, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read you? With these rights in mind, do you wish to speak to me? Okay. So it's, the wording might be different, somewhere else, but that's clearly the Miranda warnings. Okay. That's called being Mirandized. All right. It's very, very clear. Okay, short and simple. Anybody can understand this. All right. So the police must inform you of these rights. Okay. And then you have an option. All right. To say, yes, I would like to speak to you, or get the hell out of my face, which you can say to the police in the United States of America. All right. Okay. You do not have to talk to the police. You don't ever. Okay. You do not. All right. This is a free country. This is not Great Britain. All right. You do not have to talk to the police, especially when they have just told you. Okay. Miranda, to me, I've always said this, Miranda is a hint and a half for you. Okay. I mean, let's look back over it. Earl Warren made it clear in his decision. You know, you as American citizens have the right to shut up. Okay, he says remain silent. He says you have the right to shut up. He goes on to tell you that anything you say, it's not possibly, it says anything you say can and will be used against you in a court of law. Isn't that a hint and a half? Okay, he's telling you to shut up because if you don't shut up, anything you say is going to be used against you in the court. That's a hint and a half to shut up and don't say anything. All right. He goes on to implement the Sixth Amendment that says you have the right to an attorney. If you cannot afford an attorney, one will be provided for you. And then finally, they ask these questions. Do you understand the rights I have just read to you? How can you not understand that? Shut up. If you don't shut up and start talking, I'm going to use that in the court against you. Very simple. All right. And then, do you wish to speak to me? No. No. You can say no. All right. Quite a many of criminal defendants have been convicted based upon their mouths. All right. Okay. Now, I'm not an advocate of making sure that criminal defendants find ways to get around the law or anything like that. This is established law, and it's there to protect not only criminal defendants. See, today you are a great citizen. Tomorrow you can be accused by the police, and then the police are not your friend. All right. So during the majority of the time, we love law enforcement. They're great, especially when they're arresting other people and getting criminals off the street. Okay. But then there comes the day when you're accused. All right. Don't you want the same rights that these criminal defendants have? Don't you want to know that you have the right to shut up, and that if you don't, everything that you say will be used against you? Not only can, but will, or not only will, but can. All right. Yes. You want to know these rights as well. That's why it's important. And that's why we have, according to the 14th Amendment of the Constitution, equal protection under the law. That's so important to remember. All right. So those are your Miranda warnings. Miranda case is very, very important, and it's still important today. Now, Miranda doesn't apply for everything. All right. So I'm going to take a couple of minutes. Let me just say this before I do. Please like, share, and subscribe on my YouTube channel, and like, comment, and follow on your favorite podcast platform. Again, thank you guys for joining me. Today, we're talking about the importance of the Miranda versus Arizona decision and why it is still important to this very day. Why was the creation of it? Why did it happen? And why it is so important to us as United States citizens. All right. There are a couple, and I'll just talk about a couple of reasons or ways that Miranda does not have to be utilized by police. All right. First and foremost, remember that you have to be in custody and being interrogated. All right. So if the police have taken you into custody, but yet they're not asking you any questions about a crime, then they don't have to give you your Miranda rights. That doesn't make sense. Why are they going to Mirandize you for something that, they're not asking you questions about? Okay. That's not necessary. So, for example, if the police already have the evidence, okay, everything they need, maybe they have a video recording, okay, maybe they have DNA evidence, maybe they have fingerprints, okay, then I don't have to ask you any questions if I'm the police. Okay. I already got everything I need. All right. So they don't have to ask or provide you with your Miranda rights. All right. The police do have the right to ask you general questions, all right, about who you are, where you live, and not have to Mirandize you. So, for example, if the police ask you what your name is, they don't have to Mirandize you. That's not putting you in a position where you can testify against yourself or provide information that may incriminate you, okay, by asking you your name. No, okay. They may ask you where you live, okay. That's not incriminating, all right. They may ask you how tall you are, okay, what your age is. Again, that's not incriminating, all right. Another reason is if a spontaneous statement is made by a defendant while in custody. Okay? So, for example, if you are in custody and you just blurt out stuff, okay, then the police aren't required to give you your Miranda warnings. Okay? See, if people talk, okay, and give information, but that information was not given in response to police questioning or other conduct by the police, that's not incriminating. You are the one that stated it. Okay, I didn't ask you any questions, okay? But yet you started talking, all right? You started saying these things, not as a result of my questions as a law enforcement officer. The police don't have to stop you and Mirandize you. If you walk into a police station and you are not in custody and you start admitting that you killed this person or that you committed this crime, the police do not have to stop you and tell you your Miranda rights. Okay, that's because you have freely come in and given information. All right. And then there's another when there is a public safety exception to the requirement to provide Miranda warnings. For example, let's say that there is a gun that's in an unattended location, okay, and children or the public, have access to it, then that presents a public safety exception. So I'll give you an example. There's a case called New York versus Quarles, all right? And in that case, the criminal defendant had committed a sexual assault against a woman. He was in pursuit of the police. In other words, he ran from the police. The police were chasing him. He placed the gun in a supermarket. He ran into in a grocery store, and he hid the gun in some kind of carton or something like that, some kind of box. And now, what do you have in a grocery store? You have people, you have children, you have adults, okay? Well, this gun is a part of a criminal case now, so it's evidence, all right? And then there's the safety part of it. What if some little kid walks past it and sees it and says, "Oh, mommy, look at this toy," and picks it up and shoots it, and it shoots himself or herself or somebody else, okay? Well, the police don't have to stop you, the criminal defendant, and say, "Okay, I'm going to ask you your Miranda rights," which could take a couple of minutes, okay? And yet minutes are critical, and then somebody finds the gun and harms someone else or takes it for their own reasons, okay? So in cases like that, there is a public safety exception to the Miranda warnings, all right? Okay. That was a mouthful. That's a lot of information. Miranda has been attacked over the years. Of course, there are conservative individuals who, and when I say conservative individuals, I'm talking about members of the court, former members. Some of them have died. So there was Antonin Scalia. He was a member of the court. He was more of a conservative justice. He felt that Miranda handcuffed the police and that it should not have been in existence. And again, I feel as though Miranda helps the police. It helps us as citizens. It's not so much about helping the police in terms of their criminal cases. It's to protect the rights of the United States citizens. That's the most important thing that I want you all to take away from the importance of the Miranda decision. All right. It's not about your love for the police or your like for the police or you want to have safe communities. It is not about that at all. It is about our fundamental rights under the Bill of Rights made applicable to the states by the 14th Amendment. Again, it's so simple to me. The 5th Amendment, no person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. That's so important. That is so important. So why wouldn't I, as an American citizen, want my police to share that with me again, that I have the right to remain silent, and to alert me in the very beginning that anything I say can and will be used against me in a court of law. I think that's a wonderful thing for the people that work for us to tell us, to remind us, and to remind us, okay, that we have the right to an attorney, and that if we cannot afford one will be presented, and that attorney can be with us during any questioning. Those are so important. So wonderful that we have those things in our Constitution, all right, to provide us with the safeguards we need in order to ensure what Thomas Jefferson said, that we need to make sure that in this country we have life, liberty, and the pursuit of happiness, or under, the philosophy of John Locke, that we have and should not be deprived of our human rights to life, liberty, or property. All right, so important. Well, again, thank you all for joining me. I hope you have enjoyed my rendition of Miranda versus Arizona. It's so important, again, all right, that we know the law, that we know just the fundamental basics of these things that protect us, that are given to us, that are guaranteed to us. These are the privileges that the 14th Amendment talks about. It talks about the privileges or immunities of citizens of the United States. Well, that's a privilege, okay? It's a guarantee, okay, that we cannot be deprived, without due process of law, that we as people have equal protection under the law. So important. All right. Thank you guys again for listening to my discussion on Miranda versus Arizona. As I've said to you all many times, I'm on Spotify, Apple Podcasts, Spreaker, Google Podcast, Castbox, iHeartRadio. I'm still trying to build my audience. So if you guys could share and make sure you talk to other people and tell them about my podcast, I really, really strive to make these things interesting, and I do it as a service to you all. So again, I thank you for those of you that have been listening and that will continue to spread my podcast and the message that I'm trying to deliver. Thank you. Have a wonderful, wonderful rest of your day.
Thank you for listening to Think About It with Jaden Miller. Don't forget to like and subscribe to his YouTube channel, and like and follow on your favorite podcast platform.